All right, welcome everybody. I am very excited to welcome you all tonight to the Moot Court Finals. My name is Carrie Williamson and I am a partner at DLA Piper. I've been here, I'm the Deputy Office Managing Partner at DLA in our East Palo Alto office, and I've been here for about 20 years. And over that time, I've been incredibly proud to work at a firm that provides such support for community engagement and pro bono services. In North America, DLA Piper has provided over 117,000 pro bono and community engagement hours. And as part of that, as over my time there, one of the areas that I've been particularly passionate about is advocating for children, and that's a pillar of one of our community engagement and pro bono areas at DLA. And that's how I got connected with SVUDL, or the Silicon Valley Urban Debate League, for those of you who are not familiar with that acronym. I have been amazingly impressed with the students who have been involved in this program. They are going to just wow you this evening. But beyond the students, I've been amazed at the staff and the board members and the legal advisory committee members involved with SVUDL. These are people who are working tirelessly to provide opportunities and experiences for students that can put them on paths where they don't even maybe know that those paths exist. And so I'm very proud to be part of the organization and very proud to work with people like Andrew Gold, who I'm going to turn the festivities over this evening.
Thanks, Carrie. Hi, everyone. Really excited to see our students in action. I mean, we're so proud of them. You are all going to be very impressed. I can say that with absolute confidence. And the evenings, I hopefully will leave an impression on all of you to understand why we do what we do, which is to give students like these the opportunity to participate in the transformative activity of speech and debate. It was transformative to me. Anybody else who has been a debater will talk your ear off about how impactful it was in their life. And we know that in some of the communities in Silicon Valley, if it wasn't for SVUDL, these students wouldn't have the opportunities to participate in this great activity and become who they are, to develop the skills of critical thinking, public speaking, and learn to be advocates for themselves and for their communities. So we're really excited to have you here. Moot Court is a special experience, and to be able to argue in front of our esteemed panel of judges, Judge Bress, Justice Greenwood, and Justice Lee, we thank you very much for being here and doing this. I don't think that the students fully appreciate, and I don't want to freak you out, but you know, how nervous so many of the lawyers in this room would be if they were in your position. So your poise is impressive, but don't be, they'll take it easy on you, I'm sure. They won't. But I want to thank DLA Piper as well for their generosity in hosting us here and the beautiful spread that we all were able to enjoy. It really was nice. And in particular, I want to thank the students for what they're about to do, and I want to thank our staff, and particularly Quojo Moore, who worked tirelessly with these students to get them prepared, and all the students. We had a competition. These are the 4 students that have risen to the top after almost 25 other students participated and competed. So thank you to all those students. You were all great, and hopefully the experience was good for you. And we look forward to the debate. So, the Moot Court. So without further ado, counselors.
Before we get started, I want to give you a brief introduction to what you're going to be witnessing. And before we do that, though, I want to say thank you very much to my fellow coworkers, Najma Ali and Rachel Zubrin. They also worked very tirelessly with these students to make sure that they were prepared. And so I want you all to just understand that it wasn't just me, it was a whole team, and we really, really worked hard, and the students worked even harder than us. And so I hope that you give them your full and undivided attention. Before we get started, I wanted to formally introduce our judges. So we have the Honorable Judge Daniel Bress from the United States Court of Appeals for the Ninth Circuit. We have the Honorable Justice Mary Greenwood from the California 6th District Court of Appeals, and we have the Honorable Justice Cynthia Lee from the California 6th District Court of Appeal as well. And so they're here today to preside over the case of People v. Klein. Our counselors for today on the prosecution are Crystal De La Cruz Bonilla from Summit Everest High School in Redwood City, Julian J.J. Christensen from Summit Everest High School in Redwood City as well. And on the defense, we have Ojas Gandhi from Independence High School in San Jose, and Chloe Trong from Independence High School in San Jose as well. And they're going to be representing the defense and the prosecution in this case. Finally, let me give you a brief rundown of the case. So the case of People v. Klein is a case regarding the First Amendment. Sorry, not the Fourth. The First Amendment, and specifically whether or not a particular threat, or let's say a message that was sent on a social media site, whether or not this was a true threat and was not protected under the First Amendment. And so this threat was made because of a series of unfortunate events that happened between the defendant, Reagan Klein, and the alleged victim, Sawyer Smith. And so as things got worse, things that were said to one another were pretty bad, and it resulted in an incident in which a SWAT team was called to the house of Sawyer Smith, resulting in Sawyer Smith breaking their femur. So we're going to find out just what happened. We're going to find out whether or not the defense can get this true threat charge dismissed or not. We'll see if that happens. And last but not least, let me explain to you how things are going to go. The defense is going to speak first, then the prosecution is going to speak, then the defense is going to respond in a rebuttal, and then there's going to be a final rebuttal from the prosecution. Without further ado, I want to turn this over to the honorable judges to get this started when they're ready. So thank you all so much for this evening, and please have fun.
Welcome. At this time, this court is now in session. This is the matter of People versus Klein, and the court at this time will entertain the defense motion to dismiss the Penal Code Section 422 allegation which has been alleged against Mr. Klein. At this time, the court will entertain the opening argument from the defense as the moving party. If counsel will step forward, state your appearance, and you will have approximately 5 minutes to open. We will then hear from the prosecution, and then we will hear rebuttal from each side. Opening statement, counsel, please step forward.
Good evening, justices. May I please the court? My name is Ojas Gandhi, and this is my co-counsel, Chloe Trong, and we are appearing on behalf of Mr. Reagan Klein as defense today. Today, we're here to present that the comments made on the social media platform NowPic regarding Mr. Klein do not constitute to a true threat. According to the First Amendment, California Constitution, the California Penal Code 422, due to the presence of conclusive direct evidence under the Code of Calcrim 223.
So when we're looking at this, are we looking just at the words used in the social media post, or are we looking at everything?
So Justice, in this case, we will be looking at mainly this comment made on NowPic.
Okay, so why is this not a threatening comment? Somebody says you deserve to die. Doesn't that seem threatening?
Well, I was just about to introduce into the case, but yes, in regards to there are a lot of history behind the cases behind Mr. Klein as well, but we'll be taking that into factor as well as to the fact that leading into the case of the comment, there was not any real physical threat generated until then. May I continue?
So if I could just piggyback off of my colleague's comment, though, it does sound like then you are relying upon some history between the parties as opposed to just the language of the threat. Is that?
Yes, Justice. A lot of the history behind Mr. Klein will also be, well, it will be loosely attributed to the comment because it is what led to the comment made.
So can you tell us, counsel, why it is that we're allowed to go beyond the words? What is it that makes it possible for us and for you to argue that we go beyond the words themselves, which were, fairly dramatic? You deserve to die. I'm going to get you for this. You just wait. I hate you. When you're dead, no one will even miss you, you monstrous slime of a person. You think you can stick me with a $34,000 lawsuit and just get away with it? Watch your back, Sawyer. I'm coming for you.
Yes, Justice. When we will go through that history part, we'll also be proving why that comment was vague and it wasn't specific enough, and the fact that it did not attribute to a fear or sustained fear in this case, which is one of the elements under Calculum 1300, for it to be considered a threat.
How do we know that it didn't result in sustained fear?
So Justice, we know this because once the statement was made, the comment on NowPick, we see that Sawyer Smith was not feeling threatened as they were watching a movie afterwards, and again, they weren't in distress as they said in the witness statement. They made a comment afterward, which went along the lines of, quote, LOL, as if, unquote, in which they disregarded this comment in a sarcastic manner. So we know that there was no intent of execution.
Well, I think we might be talking about two different things, though, if we're talking about the intent of the speaker versus the reaction of the recipient. And so, can you tell me where in the record we have evidence about how quickly the LOL comment was posted and what Sawyer Smith was doing in the immediate aftermath of receiving of becoming aware of this particular comment?
Yes, yes, Your Honor, in the description of the case itself, it said that immediately after that comment was made, Sawyer reacted with the comment of, quote, LOL, as if, and the pretrial arguments also included the fact that Sawyer Smith was seen watching a movie afterwards. And
how long afterwards, though? And you're much more familiar with the record than I am, so I'm going to
Okay.
just ask for your guidance as far as where I can find that in our materials.
Yes, Your Honor, in the materials itself, it was on the pages near the end of the pretrial arguments, and what it basically said was that the night that comment was made,
Well,
Sawyer responded.
wasn't the comment made in the afternoon?
Well, the comment was made in the afternoon, but at that same night, the comment, Sawyer reacted with the comment of LOL, as if, and was watching a movie. Okay. So moving on, the prosecution needs to prove 6 elements under Calculum 1300 for this online threat to be proved as a true threat. We'll be moving on to the analysis of why this wouldn't be considered a true threat. The aforementioned statement not only lacks immediacy required under Calculum 1300, but also, according to witness statements by Sawyer Smith, was not enough to cause sustained fear or even an acknowledgement of a threat.
Can I ask, what is the relevance of the swatting that happened?
Justice, the relevance of the swatting that happened in this case, it's very unclear, as since the prosecution will look to put the blame on Mr. Klein. However, there were 3 people present in that building when that SWAT call was made. They were by the names of Mr. Klein, Cameron, and Marlowe. And to this
Wasn't
time,
there some evidence suggesting that your client had sent the text?
The linguistic analysts that the sheriff called upon to analyze the texts of the message that was sent to the SWAT center had an opinion that it was a Mr. Klein's, but again, there was no clear direct evidence to conclude that it was Mr. Klein that made that.
Well, what if I were to disagree and think that there might be some pretty good evidence actually that it was your client? Does that affect this motion?
Well, Your Honor, we need to consider every single element of the Calculum 1300, which every single needs to be proven. And just swatting itself doesn't hold that much value when when it is important to consider the fact that this threat wasn't specific. There was no action executed, and the fact that there was no sustained fear present in Sawyer Smith as well. So moving on, first and foremost, there was no specificity in the statement as it was quite vague and mostly just a negative comment about the person as a whole. Here we're talking about Sawyer Smith, who became a celebrity, and it is normal for people to criticize celebrities in a, negative manner. And in this case,
Well,
Mr. Klein
maybe
used
not that comment to tell people they deserve to die, though. It seems a little bit strong.
well, Your Honor, if we take this in context of a different case, the different precedent of in Ricky T, in DC versus RR, we see that a comment was made on a student's website. However, it went along with the lines of, quote, I will rip your lungs out, and I'm coming for you. So, unquote. And here we see that the court ruled that it was a threat due to the presence of specific language. Here, we can take the fact that he said, quote, monster slime of a person, as well as, quote, I'm coming for you. If you take that into consideration and then we move it to make a direct comparison with the case of DC versus RR, we see that it is not completely, we see that compared to that, Mr. Klein's case is not that specific in terms of physically executing that act.
So counsel, at this time, if you want to make a concluding statement, I'll allow you to do that, and then we need to move on to hear from the prosecution.
Yes.
Do you have about 30 seconds?
In conclusion, based on the facts that all the elements were not met as clearly, there was no sustained fear or any unequivocal means of harms to be executed. The defendant is innocent, as according to the California Penal Code 422, and there was no evidence for clear charge. Regarding the First Amendment, we cannot let this go forward because this was just a vague and harmless statement in which there was no real intent present. Mr. Klein did not physically execute any action in between the history they had before when he made that account to criticize Sawyer Smith. And what this means is that it compromises on the First Amendment and California Constitution rights, and therefore this statement itself doesn't abuse the law and it shouldn't be considered threatening. So there's no real evidence for charge. Thank you, and I would like to recede my time to the court.
Thank you very much. At this time, we will hear from the prosecution in their opening statement.
Good afternoon, Your Honors. I am J.J. Christensen, and I represent the people of the state of California. I move that the motion to dismiss the criminal threat charge be denied. The defense is trying to obfuscate a very clear threat by downplaying the very direct language used against the victim. There is also a clear history of antisocial and menacing behavior on the part of Reagan towards Sawyer that predates this.
Let me just pause you there.
Yes.
How menacing was the history? Because it seems like these people were friends, and then this got out of hand a little bit. But I don't know that I would describe it quite as severely as you are. Why do you say otherwise?
Well, I say that for a couple reasons. Sawyer, in her witness statement, says that Reagan had, even before all of this happened, before she got famous, before everything, withdrawn from the friendship for relatively no reason. And then...
How is that antisocial, though? I mean, friendships end all the time.
True. However, when Sawyer made the statement that, she was officially ending this now cold friendship, she took it very poorly and would lash out against the friendship in multiple ways, lash out against her former friend in multiple ways. Most notably, her catfishing attack, her catfishing against Sawyer Smith.
You seem to acknowledge, though, that the catfishing was not really an attack. It wasn't violent, although it may have been humiliating or embarrassing. It wasn't the sort of thing that suggested any potential for physical harm.
Well, I think it was certainly an attack against her career, certainly an attempt to tear down her newfound success as a public figure, to embarrass her in the public eye, and to,
Is that the kind of threat that is that the kind of risk or the harm or threatened harm that we're really looking to under 422?
No, but I believe it sets up a history, a quickly ramping up willingness to take more extreme action against this former friend.
Let me also ask you this, counsel. You've already gone into the circumstances that surround the actual statement that was made or post on social media. So as a matter of law, are you conceding that the language that was posted on social media was sufficiently vague that we do in fact need to look at the surrounding circumstances as opposed to simply the words themselves in making a determination as to whether there was a true threat here under the law?
I think that the words themselves are very, very strong and certainly do make a strong case for direct language against, direct and threatening language against my client. But I think it also helps to look into the background to cover sort of all of the bases here, that it's not just the language, it is also the antisocial behavior, it is also, the numerous attacks made against my client, and also against, eventually sort of bleeding into, physical attacks like a swatting attack, that there is probable cause, the police arrested her with probable cause in connection to that case.
So this is sounding, your statement sounds a little bit like a Texas two-step to me, meaning, well, yes, the words were sufficiently threatening, but even if they weren't, we should look at the circumstances. So help us understand why you believe the words themselves were sufficiently constituted a threat that we could look simply at those.
Of course. Reagan's exact words were as follows: "You deserve to die. I'm going to get you for this. Just you wait. I hate you. When you're dead, nobody will miss you. You monstrous slime of a person. Watch your back. Sawyer, I'm coming for you." This is not passive language. This is, and it's also not a rash statement made in a moment of passion. As another case, DC versus RR holds that a statement such as this made over a computer, quote, in written grammatically correct language, which this was, composed over a period of several minutes, shows intent. That the use of this threatening language, this I'm watch your back, I am coming for you, you deserve to die, these words that are...
Yes, but counsel, wouldn't you also concede there's no plan, there's no method, there's nothing specific, there's no timing mentioned. So wouldn't those be factors that would speak against the idea of this being a true threat, based on the words alone?
Based on the words alone, sorry, can you rephrase your question, sorry?
So what I'm pointing out is that in the language, there's no method, there's no specific plan, there's no time mentioned. So wouldn't you concede that the fact that those things are not included in the threat indicates that the language alone does not make this a true threat, that we have to look at the other circumstances? Does that make sense?
Yes, it does make sense, yes, it does make sense.
So what circumstances do you think are the strongest that would support this being a true threat?
Over a period of time, Reagan had carried out an unprovoked series of attacks against Sawyer's career and mental health. In her witness statement, Sawyer characterized her relationship with Reagan as estranged, that Reagan had withdrawn from the friendship without warning, and when Sawyer justifiably made the decision to cut off Reagan as a friend, Reagan proceeded to do actions such as catfishing Sawyer, tricking her into a romantic relationship with a fictional person they had created in order to gather compromising information on Sawyer and publish it to social media. They would publicly humiliate Sawyer, and Reagan Klein, in her witness statement, says that her intent was to be as humiliating as possible and to damage her career as much as possible. They would post taunting messages directed towards Sawyer from this social media account, and the only thing that Sawyer really did in response was tell their boss about an incident that had happened previous involving an oven.
Let me ask you this: after the "You Deserve to Die" post, Sawyer responded, "LOL," as if you're done now. Bye. And the defense argues that shows somebody who did not take this as a serious threat. How do you respond to that?
Well, I say that in previous cases tried in a similar manner to this, such as People versus Chandler, trying to put on a brave face in the presence of danger does not mean that you do not perceive this as a true threat. And she says in her witness statement that she saw this as a threatening message, that she was menaced by this message.
Right, but she didn't do anything in response to it. Usually if somebody is in fear, they might tell somebody else, they might call the police. That didn't happen here.
I think that, going back to your home and trying to perhaps proceed in some form of normalcy, to maintain some form of normalcy after being menaced, is a reasonable action. It might not be what you would have done or what other people would have done, but it is what she did.
But you would agree that there's no effort at outreach, there's no effort at enlisting help, much like in Ray Ricky T.
True. However, consider that if she did make some sort of, statement against this, if she would have, responded in a different way on social media or sort of reached out to police, made other sort of actions, that could theoretically blow this up into the public eye, make this into a much bigger situation than it would perhaps otherwise need to be. She was a public-facing figure.
So then you seem to be conceding that that Ms. Smith's concern was less about physical safety than reputational harm.
I think it can be both.
So what's the evidence that we have that there was concern for physical harm in terms of Sawyer Smith's actions?
She says so herself in her witness statement. She didn't have any reason to lie about that.
Other than her statements, though, what do we have about her contemporaneous actions at the time or immediately after receiving the statement?
She retreats into a place of safety, into her home.
Where in the record is it clear that that was immediately after receiving or becoming aware of the statements?
It says in, I believe, the second page here, that it was, that night that she went back to her house after this incident.
So can you be more specific about the interval of time between when Sawyer Smith read the message and when she retreated to the home, as you put it?
In the text I have here, it said the words used are, "This afternoon Sawyer posted a picture," and then later, "That night she was at her house."
So there's an interval of time.
There is an interval of time, yes.
Okay. As much as a number of hours, potentially.
Potentially.
Because the record's not really clear on that point.
Yes.
Okay.
So counsel, let me ask you to if you want to make a closing statement here, and then we'll move to rebuttal.
Of course.
You have about 30 seconds.
Okay. Reagan willfully threatened Sawyer with active language and a threat composed in a clear state of mind, a threat that was purposefully directed at Sawyer. The threat was clear, its verbiage was immediate, and the threat caused Sawyer to be in fear of her safety. She said so herself. Finally, Sawyer's fear was reasonable under the circumstances due to Reagan's repeated attacks on her livelihood and mental health, followed by the swatting attack. With all this in mind, this charge should go to trial, to be decided by a jury, not by us here. Thank you. I received my time.
Thank you very much, counsel. At this time, we will hear rebuttal from defense counsel.
Good afternoon, everyone. Judge, may I please the court? My name is Chloe Trung, and I am appealing on behalf of Reagan Klein here today as defense. Now, in this particular argument, I will be presenting an additional analysis which will go along the lines of, number one, highlighting the most important aspects of this case, and number two, rebuttaling the prosecution's arguments. Now, the first key point I would like to highlight here is the First Amendment. The prosecution tells you that we should take this case further to trial because it just allows for further investigation. However, on page 15, line 9, it states how freedom of speech is an area that has come under fire throughout United States history, and the tension between the right to speak freely and the need to protect people from dangers that may result from certain speech have been hotly debated.
Excuse me, Ms. Trong, I just want to
Yes.
make sure that I'm understanding the framing of the issue for purposes of this motion.
Yes.
And that I'm not misunderstanding it. Would you agree that section 422 is constitutional?
Your Honor, respectfully, I do acknowledge that CalCrim 422 would be considered constitutional under the grounds of meeting CalCrim 1300.
And so given that you're not challenging section 422 and its constitutionality on its face, are we essentially just looking to whether the prosecution has met their burden at a relatively low threshold of probable cause for purposes of satisfying the statutory elements?
Not only are we looking towards the elements itself that the prosecution has the burden to prove, but we're also highlighting the aspect in the First Amendment whether or not it's questioning the right to speak freely.
And so I guess that's what I'm trying to understand is whether you're making a constitutional challenge to the statute,
Yes.
either facially or as applied in this case, or whether you are conceding the constitutionality of the statute, but just requiring that in the backdrop of the First Amendment issues, we just have to be scrupulous in terms of holding the prosecution to their burden as to each of the elements.
Yes, Your Honor. We will be not only being scrupulous along the 6 elements required, but we will also be applying the First Amendment in this particular case. Okay.
Can I ask you, the prosecution, just because we deny this motion, it doesn't mean they win. They get to then try this in front of a jury. So why do you think it doesn't just present some factual issues and we should let a jury hear this?
Well, Your Honor, we shouldn't let a jury hear this because I acknowledge that the First Amendment is complicated and keeping people safe is important, and we aren't arguing against that. However, why it's important to keep this case outside of the hands of a jury is because it's questioning the fact of whether or not people have the right to free speech online. And if we do apply this case, if this case does go further to trial, then we are questioning the limits as to which how people messages on social media would be considered criminally a threat as well. And we would have to monitor multiple statements.
But you seem to agree that the First Amendment isn't absolute, and that a violation of Section 422 on the internet or otherwise can be prohibited.
Not necessarily, Your Honor. Respectfully, what I'm trying to argue here is not only do the 6 elements need to be represented, but also through applying the First Amendment, it must be followed in this particular case.
Because when sometimes in a First Amendment case, you're looking and you say, what's the value to this message? And maybe it has a political message or religious message or some other message that we want to encourage, even if it has some downsides associated with it in terms of public safety. I'm struggling to see what the value is in this particular post, because it seems that it's just communicating to somebody that they want to harm them.
Yeah, Your Honor, respectfully, this statement itself, we aren't arguing that the statement carries important weight, but the fact that the statement's vagueness not being conveyed as a threat is important to consider the fact that it should not be taken to jury for the reasons that the statement, similarly across other social media platforms, we can see in different cases like People v. Martinez, for example, where it's happening a million times a day on numerous different platforms, going back to the prosecution's mention of DC versus RR. So if we were to take this case in particular to trial, we would also have to consider numerous cases before illegal as well. May I continue? Okay. So Mr. Klein made a general statement that I will acknowledge is not a nice statement, but is a general and emotional statement over their extreme distaste over an individual, Sawyer Smith. Now, if you allow this statement to go to trial, Your Honor, happening millions of times a day across numerous different platforms, then all of that would also have to be considered illegal as well. Now, the First Amendment must protect this.
What's wrong with that?
I'm sorry, Your Honor,
What's
part were you referring to?
wrong with prohibiting this kind of language?
Well, respectfully, Your Honor, this type of language was responded to in kind of the heat of a moment. And if we prohibit language
How do we
such
know
as
that?
this, or we,
How do we know that it's really in the heat of the moment when it's posted publicly, it's very detailed, it's not just a one-liner.
well, Your Honor, in the witness statement, Mr. Klein also states how he was feeling incredibly emotional after being stuck with a $34,000 lawsuit, and he did reply in haste.
But under a 995, under section 995, we are looking at a very low standard of proof, are we not?
Yes.
And so, given the low burden that the prosecution has to meet under 995, does it really matter that there's contrary evidence in the record from your client?
Yes, Your Honor. Respectfully, it does matter in this particular case due to the fact that not only do we have to keep in fact of the language present in the particular statement itself, but we also have to look at the other 6 elements in regards to if it was unequivocal, specific, or if there was any sustained fear present. May I continue? Okay. So what my client did was express his emotions distastefully on a public platform, similar to the case of In re George, in which a student wrote a piece of dark poetry, including some disturbing language. However, the court ruled this particular case not to be a true threat because it lacked immediacy, specificity, and the unconditional element for it to be considered a true threat.
Well,
There was
except
also-
it was also an artistic expression.
Yes.
And I don't think, would you concede that there's no way really that your client's statement here could be considered an artistic expression?
Well, Your Honor, I'd argue that expressing oneself on social media, like many people do, would be considered not only similar to how one writes their emotions on paper, but it's essentially outlining one's emotions on a public platform.
Well, that's expression, it's not necessarily artistic.
I'd argue that expression does play a role into art.
Well, that doesn't mean that art necessarily plays a role in expression, would you agree?
Yes, but I'm making the connection between the fact that the client in re George expressed their opinions and their emotions on a public platform similar to, on a piece of paper similar to Mr. Klein.
In George T., however, were the poems addressed to particular people as opposed to shared with people?
They were addressed to 2 specific students.
So counsel, I think at this time I'd ask you to make whatever final comments you want to make. I'm going to ask you one question, though, a little bit of a ringer, I will say,
Okay.
before you close, which is, are you acquainted with the very recently decided United States Supreme Court case that was just issued on
Yeah.
this topic? Can you tell us from your perspective in what way that case hurts or aids your case here?
Of course, Your Honor. So the most recent Supreme Court ruling was in the favor of the defense, and it was a 7-2 ruling, I believe, which talked about specifically the First Amendment and the constitutionally right of protected speech. Now, this case plays a role into our specific case for the fact that they focus primarily on the intent behind the message. Now, it's important to note that similarly, not only in the case of Reagan v. Klein, People v. Klein, but also in the case of People v. Jackson, the jury found the defendant's comments to not constitute as a true threat, even though it was incredibly specific and grotesque. Similar to a past case the prosecution has mentioned as well of DC versus RR, where the threat was ruled a true threat because of the unequivocal, clear, and specific language. So essentially what I'm trying to argue in this particular speech is how Because of the Supreme Court's ruling on the basis of intent, we can see that Mr. Klein did not have the intent for it to be carried out. Now, concluding, Your Honor, it is human nature to survive, and I'm going to address the argument of sustained fear. Now, even in the roughest of conditions, humans are constantly pushing for survival. Now, if Mr. Sawyer Smith truly felt he was at threat, if he felt his life was at risk, or if there was any possibility of dying, wouldn't it be logical to assume that he would take more action in preventing this death? Now, like many of the victims in other cases, it would be reasonable to assume that if one's life was truly at risk, they would take further action to prevent it. Your Honor, the prosecution has the burden to prove 6 elements, however, some have not been met in regards to no sustained fear, the threat failing to be unequivocal and specific with clear intention. Therefore, my client is innocent as of California Penal Code 422 and Calcrim 1300 have no clear evidence for charge, making this statement protected under the First Amendment. Thank you, and I'd like to receive my time to the court.
Thank you very much. And at this time, we will hear rebuttal from the prosecution.
Good afternoon, Your Honor. I am also on the prosecution side. My name is Crystal de la Cruz, and I am here to further explain why the defense motion be denied. The threat that Regan had posted directly under Sawyer's comment was directly a threat. Now, I would like to bring your attention to when Regan said, "Watch your back, Sawyer, I'm coming for you." This comes across as nothing else but vengeance. And what better way to get revenge than to watch the person who stuck you with a $34,000 lawsuit get hurt? Bringing a motive for Regan to have left that threat because he wanted to clearly communicate to Sawyer Smith his intent to hurt him, regardless if Sawyer had taken him seriously or not. This case is similar to the City of San Jose versus Gambler case, where a man was convinced that the government had it out for him. So he demanded an audience with the clerk office and was allowed to speak. He said, "What does somebody have to do to change policy around here? Do you have to take matters into your own hands like the black man in Missouri?" Now, the ruling of this case was a true threat because they said that the only intent required for a true threat is that the defendant intentionally or knowingly communicated the threat. Now, in relation to our case, even if Regan had no intention of carrying out his threat, he clearly knew what he wanted to communicate to Sawyer Smith.
Does it matter, counsel, that this is a communication that's online and public for all practical purposes?
Yes, it does matter because Regan was directly targeting Sawyer under his post. That's where he left the threat. It was directed towards a specific person.
So I guess I'm not questioning that it's directed at a specific person, but is the public nature of it, sort of the performative nature of online communications, is that a factor that we should also be considering in determining whether the circumstances make this truly threatening?
The circumstances. Can you rephrase your question, please?
Well, if, for example, Regan Klein and Sawyer Smith were together in the same room, and the words were communicated with, heightened emotion and immediacy, and they're sharing the same space, and nobody else is around, would you agree that that plays out differently than when somebody posts something online in a public forum? However, even though it's directed, even though the target is clearly identified, but there's no immediacy of access. It's not even clear when the comment is going to be read. Are those factors that are significant for purposes of our consideration of this issue?
Yes. I would say that because well, actually, it depends. In person is different from online, but they could both have a similar could both have a similar outcome. So, for example, in the case where People versus Chandler, the defendant was waving a golf club, and the victim said, "Bring it." And they tried acting brave. They tried acting brave during that situation, but that doesn't mean that they didn't feel fear. Similar to my case, the defendant had made a very threatening statement, and the victim, Sawyer, had responded to it in a brave way, since Sawyer is an influencer and he already been mocked enough by Regan. So that's the only reason why Sawyer had responded in that way, as LOL as if.
So one of the things that we look at, if the statement itself tends to be vague, and it sounds like the prosecution is conceding to some extent that the language is somewhat vague. So one of the things we look at is whether there's conduct that would indicate that this was a threat, that makes this a true threat. Can you tell us whether there's conduct here on the part of Regan that would cause Sawyer to feel threatened?
Yes, so even if the statement was vague, it has been proven before that vague statements can still constitute as a true threat. Like the People versus Martinez case, the defendant had made a threat to the supervisor saying things like, "I'm going to get you." Similar to our case, Regan had said similar things saying, "I'm going to get you, watch your back, I'll get you." And despite that case being vague, it still was a true threat.
What about the swatting? Because even if it was the same person, what does it have to do with this?
Well, Your Honor, the whole reason we're here is because Sawyer went through the swatting. And the reason the swatting is an important event is because after the threat was left, the follow-up event was the swatting, which coincidentally did hurt Sawyer during the incident.
But that's not what was threatened, right? I mean, I just am wondering, there seems to be almost a disconnect between these events. You're arguing there was a specific threat made by Sawyer, and then we have a swatting, which seems like something different.
Are you saying what's the relations between the threat and the swatting?
Exactly, yeah.
Oh, all right. So, well, Your Honor, the relations between the threat and the swatting is the fact that immediately after the threat was posted that same night, the swatting had happened and it had hurt Regan. So it had hurt Sawyer. So when Regan had stated, "Watch your back, I'm going to get you for this," something did happen to Sawyer, which was...
You want us to first believe that the swatting text was Regan, and then you want us to believe that when Sawyer posted the, when Sawyer posted that the text that Sawyer was suggesting that the swatting was the carrying out of the threat?
Yes, because...
What evidence is there of that?
The evidence is that the officer had questioned the suspects about it after the swatting, and which led the officer to have probable cause to arrest Regan, since the swatting was a follow-up of the threat.
If I disagree with you on this point, I think that the swatting is just not that related to the text, or at least that you haven't provided enough evidence of that. What happens then? Do you lose?
Are you saying if the threat is what could happen after the threat?
In other words, if I look at the swatting and I say I don't think there's enough of a connection from the swatting to the text, then does that mean you lose this, or do you still win based on the face of the text and some other actions?
Well, there is a high probable cause that Regan would have done the swatting. And if the swatting wasn't Regan's fault, then there is still other chances for Regan to try to do any intent on Sawyer's side. Since Regan and Sawyer were already friends, they both have Regan has some type of information on Regan has some type of information on Sawyer that could get Sawyer hurt. Like, for example, Regan knows where Sawyer lives. He still has probable cause to be in fear.
So counsel, we're going to ask you to do your closing statement here. Before I do that, however, let me just ask you the same question I asked the defense. Are you acquainted with the brand new U.S. Supreme Court case that just came out on this topic of true threats? If you are, great. If you're not, we understand. It was just issued yesterday. So.
I haven't really been keeping up with the news.
All right, so we're interested in hearing your closing statement at this time. Thank you.
To conclude this, Your Honors, the First Amendment does give the right to people to speak, protest things. However, it does not grant the right to people to give intentionally or unintentionally threats out to others. Thank you, and I think I exceeded my time. Yeah.
Thank you very much, counsel. That at this time concludes arguments in this case. I suppose the panel would meet and confer and make a decision about what our ruling would be. We're supposed to do that in private. You're not allowed. Just saying. So maybe I'll turn the proceedings back to Mr. Moore, and he can give us some direction about what we're supposed to do next.
Sure thing. Sure thing.
While the judge and justices are thinking about how they would rule, I want to first of all say thank you very much and congratulations to all of the students. Can we give them another round of applause? It's very difficult. They asked way more questions than we did in practice, and interrupted them way more. I probably would have been sweating buckets, so I just want to say that all four of you did an amazing job, and I'm very proud of you. Thank you so much for taking the time to do this and for taking part in this. Okay, so what we're going to do is, after I hand out something special to our students, we're going to have the opportunity for feedback. Roland is our executive director, is going to be the one to carry that through. But I want to present them with something very special. We had a lot of students sign up to do this. We had more than 30 students sign up to participate in Moot Court. And it has been a multi-month process. It has been many hours a week preparing and practicing. It has been many hours getting ready the night before to actually answer questions from Santa Clara County judges, and San Mateo County judges. So the students that you see before you have gone through many, many, many moments of very intense questioning in order to get here. This is a privilege and an honor for them to be here. They have shown that they are dedicated, and we are very happy and proud of them. We love that they're here to showcase the talents that they have. And so to cap that and to make this a real thing, I have some awards for them. And so to Chloe Trong and Ojas Gandhi on the defense, thank you very much for the work that you've done over the past few months. And thank you very much for the amazing display that you've put on for everyone here. We think that you're amazing, and because of that, we want to give you these awards for the 2023 SVUDL Moot Court. And to JJ and Crystal, you as well have put in a lot of time, a lot of work, a lot of effort. Crystal, I know that you, because I drove you here, wrote most of your speeches out on paper because you couldn't print them out. You didn't have a way to do so. So I think that speaks very highly to both your character and your work ethic, the fact that you're not going to let anything get in your way to be prepared. So I want to both award you and JJ our 2023 SVUDL Moot Court Award. Thank you so much for the prosecution. And so I will now hand things over to Roland. Roland, please come up and carry us away.
Thanks, Woodruff. So I'm actually going to turn it back over to Judge Bress, Justice Greenwood, and Justice Lee. In the spirit of learning, our students are always looking for feedback. They're always looking for opportunities to evolve and grow as speech and debate competitors. And so I would love to open the floor to you all and very publicly share any feedback that you may have, positive or constructive.
Should we share the verdict first?
Or you can start with the verdict, that's fine too.
Oh, sure. Yeah, we'll start with that. So if the nature of this motion was actually a trial court motion, so what would happen if you were in a trial court is there'd be one judge, and the judge would either grant or deny the defense motion to dismiss that particular charge against Reagan. But these unfortunate students had the pleasure of appearing before the Court of Appeal, which is always a 3-member panel and is often typical in the Court of Appeal. There's not always agreement. And so in this particular instance, I will not identify the panel members who voted any particular way, but 2 would vote to deny the motion to dismiss, and 1 would vote to grant the motion to dismiss. So everybody won. There was a dissent. And so it shows very well argued and also a close. This is really a timely case because the U.S. Supreme Court just ruled on it. I couldn't even name the opinion. You probably noticed I was like, yeah, that opinion, or that one. I didn't know its name. But anyway, so I think now maybe some feedback. Let's start with Judge Bress.
Sure. Well, I just want to congratulate each of you for doing this because you made it look easy, but we all know how difficult it was, and to have to get up in front of a lot of people and to have to not just speak, but speak, in the way lawyers speak, which is you can't just say something. You actually have to have authority for what you're saying, either in law or in fact. And I just want to say, this was just remarkable to see how each of you did this and the level at which you're doing this. And so what a great experience, I think, for everybody to see you guys in action. I hope you had fun doing it because usually, the preparation, you're so nervous, but then afterwards, it's a great feeling of accomplishment. So I hope you have that here. I just want to say, I was writing down for each one as you went, just sort of moments that I thought were great moments. And I thought, just when Justice Lee was asking you, where in the record was something, and you were dialed in on the record, and that was really impressive. And JJ, you had a question from Justice Greenwood about words and actions, and you said, well, the words are very strong, but the context also helps. That was a great pivot moment, very artful pivot. And Chloe, in response to my question actually about the value of the speech, I thought it was a very nice turn to talk about vagueness, a very sophisticated move, and in First Amendment. And then Crystal, I thought the questioning, I think was from Justice Lee about in-person versus online. I thought that was handled very nicely in talking about that. So I thought, all in all, awesome job. And I think, once you do this once, it gets actually easier. You'll never wake up in the morning of an argument not nervous. That's totally normal. The people who do this for a living, and even the people who've argued in front of the U.S. Supreme Court 100 times would tell you that every single morning they have to do that. That's a nerve-wracking experience. But you all projected just incredible confidence. And it wasn't just what you said, it was kind of how you said it and the support that you made for your points. And so I was just thoroughly impressed, and what a great job.
So I just want to acknowledge the difficulty of the setting here as well. I think that, it's one thing to be having this conversation with the bench, and not just one judge, but 3 judges. But you're also doing it in front of a very significant audience who are all in your line of sight as well, which makes this much more of a high wire act, I think, from a stress standpoint. And I think it also can, it makes it difficult because it can divide your attention. And I thought all of you handled that very well in terms of focusing on the people who were pestering you with questions. And I want to echo what Judge Bress said as well in terms of the way each of you handled yourselves with authority. And you were interrupted a lot. And that can happen with a single judge, but it's definitely going to happen more, and it's going to throw you off coming from 3. And so I think that all of you really, I know that you had remarks prepared, and I know that we didn't let you get to that except at the very end. And I thought that you all handled that exceptionally well and exceptionally gracefully, and under circumstances that I think really were calculated to ramp up stress too.
I was so impressed by the fact that you had the language of the cases on the tip of your tongue. We see a lot of lawyers come and argue before us, and they often don't have that mastery. I'm just going to be very candid with you. So that really speaks to your level of preparation, which was, I think, really the key to all of this. And I was impressed by the fact that, as Justice Lee was, by the fact that even though we wouldn't let you stay on script, you also kept trying to come back to the points you wanted to make. And I would say that Chloe and Crystal were particularly adamant about that. So in the right way, it was like, back off, judges. I have a few points here that I also want to make, despite the questions that you're asking. I thought that was really well done. I want to acknowledge JJ's Texas two-step. I was trying to get him to concede. And you just weren't going to quite go with me on that.
That's my mom. I die on every hill.
Yeah, I guess. I mean, I was using my justice voice and everything, and it just it didn't work. So I was very impressed by that Texas two-step, and I in many ways I felt like is it Otis? Excuse me. I'm sorry, Otis. I think you had, in some ways, the hardest job because you were first up and you prepared the way for them. Once you were done, everybody knew, oh my God. You had to go through and I could see you, you kept like, hey, wait a second, I've got things I want to say. But you did such a great job of being able to respond to the legal questions that we put to you, and they were not easy. They were sophisticated. So thank you very much. It was really a pleasure to hear from the 4 of you. We enjoyed it. I enjoyed it thoroughly. I know all 3 of us did. Congratulations.